as well.
Take a moment to remind our viewers, this is a live call-in show. We invite you to call in. Our number here is 617-708-3290. Again, 617-708-3290. My name is Tim Lynch, your host of MLGBA Legal Lines, and today our guest is Ben Kline of GLAAD. Now, I take it the referendum, though, wasn't such that the legislature in a number of years from now can't revisit the issue and pass the law again.
Absolutely, and the legislature will at some point revisit the issue and pass the law. So in all these states, marriage is going to happen eventually because the work is being done. So Maine will ultimately get there, and people are turning their sights now on Rhode Island. There is...
Yeah, what's going on in Rhode Island?
Excuse me.
It's kind of conspicuous, that little state
surrounded. Yeah, it's surrounded by Massachusetts and Connecticut, and I think that there is a fair amount of support in the legislature in Rhode Island, but Governor Carcieri is adamantly opposed to marriage and has said that he will veto any marriage bill passed by the legislature. So what that means is the legislators are unwilling to take a vote when they know that they will simply be overridden by the governor. So the real focus in Rhode Island is that they have term limits, so the governor's term is up in 2010, and there will be a new governor, and we hope that it will be a pro-marriage equality governor, and then the stage will really be set to work on the legislature and to get the votes passed when the legislators know that the governor will sign the bill.
Does Rhode Island recognize out-of-state same-sex marriages?
Well, there's a bit of an uncertain landscape around that in Rhode Island. There is an opinion from the Attorney General Lynch, that Rhode Island should recognize these marriages. There's one case from the Rhode Island Supreme Court in which they didn't recognize a Massachusetts marriage, but it was only in the context of divorce, and they were specifically interpreting the provisions of the Rhode Island divorce statute in refusing to grant a divorce in Rhode Island to a couple married in Massachusetts. It's unclear how broad or narrowly that may be construed. So I think recognition in Rhode Island is a somewhat uncertain landscape at this time.
Wow. So, well, hopefully you won't have to do that. Hopefully there will be a change.
Right. I mean, that would certainly be the best option. The other major thing that's going on in Massachusetts right now is that in March, GLAAD filed a lawsuit to challenge the Federal Defense of Marriage Act.
Now explain for our that's DOMA, Defense of Marriage Act. Right. Explain for our viewers what exactly that is.
Right. Well, what that means is that typically in this country, it's the states that determine who can get married. And in Massachusetts has determined that same-sex couples can get married, and they're as married in Massachusetts as any other couple. But what the federal government did was in 1996, they passed a law that said that for purposes of federal benefits, the federal government will only recognize a marriage between a man and a woman.
And it's never been done before.
It's never been done before. The federal government has never waded into and interfered with state determinations of marriage the way they have in this one particular instance for lesbian and gay people. So what the federal government has done is they've created two classes of citizens: married heterosexual couples who get federal benefits, and married lesbian and gay couples who do not get federal benefits. So we challenged this law, and the federal benefits are significant. There are over 1,100 federal benefits that are tied to the status of marriage, and they're very bread and butter significant issues for people. So, for example, if a couple is married and they're both collecting Social Security, if one spouse dies, the surviving spouse will receive the Social Security benefit that's the higher of the two benefits paid. So if your deceased spouse was receiving a larger Social Security benefit, the surviving spouse gets that higher benefit. And obviously that's a federal policy to protect families and couples, to ensure that there's financial stability when one spouse who's receiving financial benefits passes away. That benefit is denied to same-sex couples. We have a a plaintiff in our case, a man named Herb Burtis, who lives in a small town in western Massachusetts, he and his husband were together for 60 years.
60 years.
They met in college,
Wow.
and Herb cared for his spouse in the last years of his life when he was suffering from Parkinson's disease. And after Herb's partner John died, if they were a heterosexual couple, Herb would have received John's Social Security benefit. It was the higher benefit. He was the higher wage earner in his life. But because they're a same-sex couple, that benefit was denied to Herb. It's $700 a month, which is the amount he pays for his Medicare supplemental insurance.
Wow.
So it's basic issues of fairness, and couples that are similarly situated are being treated differently. So we've brought an equal protection challenge to challenge cases like that and other areas where people are denied spousal health insurance in the federal government. If you're a postal employee, you don't get spousal health insurance. If you were a heterosexual married couple, you would. People have to pay tax if you're working for a private employer and you get spousal health insurance. You have to pay federal tax on that benefit.
Whereas you don't.
You don't if you're a heterosexual married couple. So our argument is really that this is a denial of the equal protection of the law. The federal government has singled out one class of married couples for differential treatment without any justification. There's no justification related to any health or safety concern or anything other than the discriminatory action of the Congress in 1996. So that case has been filed in, excuse me, in U.S. District Court in Massachusetts.
Well, who do you have for a judge?